exciting news here at Fellowship Hall in Leominster. You can see on the wall, there are brackets. On the back table, there are mini splits. So next month, you're going to have to go back to feel the air conditioning.
So bring your sweaters.
That's right. It's going to be a lot of fun. This is going to be great.
Yeah.
So, as you probably know, my name is Jeff Turcott. This is my amazing wife,
Kelly Kurtz.
And our business is Simply Well Seniors. We are realtors, but we're different. And we help seniors navigate the journey to the next place they call home. Sometimes even if that home is still the home they're living in now, and they just want to downsize. We help folks do that as well. So today's panel discussion, we have two great panelists, friends of ours. We're talking about trust wills, planning. That's what that's our message a lot throughout these seminars is planning. We're great planners. Things that we've been working on this past month, we've been working with someone that didn't quite plan as well as maybe they should have, but we slowed them down and we put a plan in place. And we're working with them to get him downsized and get him moved to the next place he wants to call home. Living in the house for over 50 years, married his wife passed away about 6 years ago.
Yeah, and he still had a lot of things, basically everything from when she passed. So we went through her closet and her drawers and kind of processed all that stuff with him over the last month or so. And he just hasn't been able to do it himself. But with our support, he was able to get through things. And he's feeling lighter and ready to now move to the next place, which is, he just kept getting stuck. He wanted to go, but he just couldn't do it. So
you like the idea of moving to a smaller place, but just didn't know where to start. Physically, emotionally, all of it that goes with it. So you're stuck. Yeah. So Kelly got him unstuck. Said, let's go. So that's exciting. Coming to the end with another client of ours who were great planners. We met them about a year and a half ago, and they're going to be moving next month. And so this coming weekend, actually this Saturday, we're going to rehome an awful lot of their personal possessions. We're going to participate in the Leominster yard sale this weekend. And we're going to help them do that because it's the stuff that has some value to someone and probably not. She's been working on Facebook Marketplace, those kinds of places as well. But the Leominster yard sale is you get so many people out.
Yeah.
So we're going to help them with that, and they'll be ready to go. The move-in date is potentially June 10th, and we'll be ready to go with them. So excellent. All right. We're sponsored again this month by Heywood Wakefield Commons on 50 Pine Street in Gardner. We were just there this past week. Christy Livingston is here today. If you'd like to say a word, and you also have an event coming up that you'd like to announce. We have a microphone for you.
You are. Welcome.
Thank you. I'm Christy from Heywood Wakefield Commons in Gardner. We're an assisted living community in one of the renovated buildings of the old Heywood Wakefield furniture factories, and it's beautiful. We've been in September. We'll celebrate our 14-year anniversary, and we provide affordable options for folks who are worried about what happens if my money runs out after I move into assisted living. So we give peace of mind to residents who maybe are concerned about that. But I'm very excited about an event we have coming up on June 4th, actually across the way at the library in Gardner. They have a beautiful art gallery at the library in Gardner, and our residents have been working for the last year, a select group of our residents, on a project called Photo Voice. And it's a specialized project where they went to various places, took pictures that intrigued them, and they've been working on writing different descriptions, what these pictures meant to them. So it's a photography and also and put words to their photographs on display at the library. So we're having an opening reception where you can meet the artists and see their works at the library in Gardner on June 4th. From 2 to 4. So if you can come, there's no RSVP required. We'll have some light refreshments. I did put a few of our flyers on the table in the back. If you can join us, we'd love to see you. And thank you. And Jeff and Kelly have been very helpful to one of our residents and their families going through a lot of transitions recently, and I can see firsthand how great their services are. So thanks for having us.
Thanks, Christy. Appreciate that. And we owe you dinner for that little promotion there. Fantastic. That'd be great. we enjoy working with the folks at Heywood Wakefield Commons, and the coordination is really easy, and it's been a pleasure.
They're going to be presenting next month here at our seminar. We're going to be doing one on assisted living communities. So they're going to talk about more specifics of their program. But if anyone's interested in taking a tour, it's a fabulous building and a great place. And Patty Peterson's here as well from the Gables. So she's going to be here next month too. So got some good ones coming up.
So we're also sponsored by NXT Level Studios. Our videographer, Keith, is here again this month, as he's been with us from the very beginning. And Keith helps us put these programs so we can put them on our YouTube channel and put them on our webpage. So if you have someone that you think might be interested in the topic that we're talking about today, but they couldn't make it, point them to our YouTube channel or to our webpage, and they can see the same information. So you're all going to be YouTube famous, okay? Because you're in the room. Michelle Moore, and I think you already are, though. So our proven process, like we've been talking about, Simply Well, Simply Organized, the decluttering, downsizing, organizing arm of our business, Simply Well Seniors, estate liquidation, sale of the real estate at the very end. That's that arm of the business. And Simply Well Seniors Move Solutions. That's our move management arm of the business as well. So from the time that someone decides they'd like to move from their house to someplace different, we can help them the entire step of the way. Sometimes we want to give out as promotions a bag of nuts and a can of soup, because we are soup to nuts. You love that? That's good. That's good. It is.
And the gentleman that we're helping that had just lost his wife, he's moving to a condo coming up. His house is just going on the market this week. But we're going to help him with the whole move management. So we'll pack all of his stuff and then get him to the new condo, unpack everything, put it away. So we basically do it in a day, kind of like the HGTV reveal. He'll go out to lunch, do something, come back, and his stuff will be put away. His bed will be made. He'll be ready to sleep there that night. The boxes will be gone. So it really helps seniors make that transition much smoother than months and months of packing, unpacking, tripping over boxes potentially. So that's a service that we really feel is vital to complete the process.
Mm-hmm. Great. So we brought our easel this month, and I think what we're going to do, why don't we pull it out front a little bit?
I'm going to pull it out.
Yeah. Is if anyone has anything that they would like to get answered today, let's put them on the
Yeah, so we've got the estate planning attorney and the financial planner, and we have questions prepared to ask them. But if you came today thinking, I really want to know about this or that, barring anything very specific that might only be your situation, if there's anything that you really want to hear today, let us know. We'll write it down. We'll try to incorporate that into their questions. So does anyone have anything they're thinking of? I know, Peter, you said trusts when you came in.
Yeah.
And we are going to talk on trust, but just you're thinking time frame of when they should be put in place is what you had said.
Yeah, that's my understanding is that
Last minute decision. Okay. Very good. Anyone else have anything they're thinking, financial planning or estate planning, that they're worried about? Wills, questions about anything to do with that?
Mm-hmm.
Distribution, trying there's a whole bunch of different types.
Okay.
Mhm.
Okay. Types of trusts that are important. Did you have anything? Okay. Okay.
Changing representatives, trustees.
Okay.
Good. Yes.
Yes.
Yeah, what's the
Okay.
difference between power of attorney and personal representative?
Guardianship,
Those
all that.
guardianship. Differences in that as well.
Okay. Yeah. Okay.
What else? And then we'll, as things come up,
Yeah, you can ask questions as we go along, but we just thought if there was anything someone said, we don't want you to leave today and say, oh, the one thing I wanted to know was this, and we didn't get it answered. So this will just help us a little bit, and they're going to offer a wealth of knowledge today, and both have their cards up at the table and are available if you want to make appointments with them or have another conversation with them outside of this, then you can definitely do that. Slide these back a
Okay.
little bit. All right. You want to start with Casey?
So, back by popular demand, we have Casey Freeman with Merrill, and I have a short bio here, and correct me if I have any information incorrect, Casey. Casey Freeman is married. His wife Heather also works with him. They have two wonderful little girls. One of them is having a birthday today.
And a baby on the way.
And a baby on the way.
Any minute, right?
A month.
Number 3.
So he's
number 3.
He's a busy man. So Casey, he's a portfolio manager, and he follows a disciplined process of managing wealth that begins with listening to a client's needs and helping to ensure that every strategy is grounded in understanding what each client wants to achieve. Casey holds, he earned a BS in economics at University of Tampa. He holds an accredited asset management specialist and chartered retirement planning counselor designations. So please give me welcome Casey Freeman.
All right. Very good. Next, we have Brianna Boudreau-Cicino, who is someone that I met, I don't even know, years ago through a BNI group, a business networking group, and we've stayed connected ever since. She's fabulous. She joined Gelinas and Ward in 2020 as an associate attorney with a focus on estate planning and estate administration after spending many years of her careers as an associate at a small family law firm handling mainly divorce, custody, and mediation matters. Brianna received her Juris Doctor from Quinnipiac University of Law in New Haven, Connecticut. She's a graduate of she's a Magna Cum Laude graduate, with academic concentration in family law and civil advocacy. Dispute. I usually print this off, but because I had to do it on my phone, it's so hard to see. She is also a graduate of Assumption College in Worcester, having completed her Bachelor's of Arts with a double major in Sociology and Psychology, summa cum laude, in 2012. As a Leominster native, Brianna appreciates the opportunity to continue to serve her local community as part of Gelinas and Ward and assist clients with their estate planning and estate administration needs, ranging from simple wills to more complex trusts. Welcome, Brianna. Come on up.
So we gave you the questions in advance, and we're not going to ask you any of those.
I didn't prepare anyway.
I figured as much. Casey and I are friends. So I'll just start with, let's talk a little bit about what are some of the common misconceptions or overlooked aspects about, estate planning. We're talking about, not only the legal aspects, but about, the financial aspect and that kind of thing. What should people kind of be aware of? What's some of these misconceptions? I'll start with you, Brianna.
So I would say, and thank you, Kelly and Jeff, for having me here today. I very much appreciate the opportunity. Sure. I would say, and certainly if anybody can't hear me, please let me know and I'll speak up a little bit louder as well. I would say, I meet with clients all the time about estate planning. And one of the most common things that I hear from clients is that I want to have a will to avoid probate. That's a big misconception that a lot of people have. And that's not to say that a will is not a very important aspect of an estate plan, but it doesn't help to avoid probate. A will is a document that gives you directions for the probate process. It says who's in charge of handling that process. It says how the assets are to be managed and distributed, but all of that is done within the probate process. The way to avoid probate, that's where trusts come into play. So that's another piece of estate planning, and clearing up that misconception is a huge starting point when starting to discuss the estate planning process.
Okay, that's good information. People say, I want to avoid this probate, so I have a will, so I'm all set, right?
Right.
Well, probate is actually the opening an estate and without a will, then the state then is making decisions. Am I correct? Or the court?
So there are still laws in place that dictate who would get assets in the event that there isn't a will and who is in charge of managing that process. But there is additional levels that come into play if there isn't a will, and additional complications that can come into play if there isn't a will. Okay. So a will is important. It's not the way to avoid probate.
Do you need to have a will in addition to a trust, or could someone go right to a trust?
So when we are setting up estate plans at our office, we're looking at a comprehensive estate plan. And with having a trust in place, we're also going to have a will, which for some people may seem a little counterintuitive. But the reason for the will when you're setting up a trust is to make sure that the trust is the controlling document. So the will is typically what's called a pour-over will. And what it says is that if any assets are not in my trust when I pass away, I want them to be moved into my trust through the probate process and administered under the terms of my trust. So the will is the way to make sure that the trust is the one that's controlling how things are managed.
I see. Okay. All right. Pour over will.
Pour over.
Okay. All right. Great.
If the assets are already in the trust, if the trust is funded, and I think Casey. That's a great question. There are other ways to avoid probate as well. And working with a financial advisor is helpful in this regard because many times they are the ones assisting the clients with the steps outside of setting up an estate plan to avoid probate. So having joint owners on an account or an asset ensures that that asset avoids probate. Having named beneficiaries on certain types of accounts ensure that those assets avoid probate. So those are other steps that somebody can take to avoid probate.
Let's talk a little bit about that, Casey, about beneficiaries and.
So I'd piggyback on her piece about the beneficiary. We tend to do beneficiary audits too on accounts. And I think one of the misconceptions too is if people have a trust or a will, that it supersedes anything that might be on an account. So if you had a beneficiary in one account, but your will or trust says to do this, it's not going to matter. If your account has one of your children as, say, transfer on death, and the will says to give it all to the other child, they're going to follow what the account says. So a big misconception is to make sure that what you have titled on your accounts matches what your wishes are. I've seen a lot of things where people had old IRAs or other accounts that had an ex-wife or an ex-husband, and they passed away, and the ex has a claim to it, not their current spouse, because they're the sole beneficiary. 401ks, etc. I had someone in our office actually who passed away, and her ex-husband was the beneficiary, not her current spouse. So that was a big problem, but there was no claim. The current spouse could not really do anything about it. So one big misconception is to make sure that your accounts match what you want to have happen, because it's going to supersede a will if one account says this or that. One other big things we've noticed is someone might do a trust. Can you hear me good? All right. Someone might do a trust, they don't fund it. So they do a trust, but they never put anything in it. I've met with countless people that said, oh, I have a trust with my spouse, the A and B family trust. And I'd say, what owns it? What does it own? They say nothing. Like, so it's has no point. Because the trust will have zero, you could have all these other accounts and there's nothing in the trust, so it's not going to follow the wishes of the trust. So if you do get a trust, you need to make sure you work with the attorney typically to set up what is called a funding letter. And that usually gets sent to me and says, here's all the accounts. We want these accounts to be named as the trust. And we do the paperwork and change it to make it look that way.
So now you said if a beneficiary is on an account, there's no way the will not supersede it. Is there any other legal action someone could take to, if there really is a dispute, like an ex-husband and now there's dependent children or a current spouse, there's nothing to, no workaround? None that you've seen.
Yeah,
you can sue. Okay.
You always have the court as, an avenue there. And certainly, there might be a way to fight it to have the ex-spouse not receive that. I mean, by virtue of Massachusetts law, typically any spousal designation as, whether that's an appointed representative or a beneficiary is severed as of divorce. doesn't necessarily mean that a financial institution is going to know or understand that or follow that. Certainly the probate court is always a recourse that kind of negates the purpose of having these types of designations in the first place, and keeping up with beneficiary designations and making sure your estate planning documents in line is preferable.
I'd say one other thing on the misconception is that you might do all this planning thinking there won't be a dispute or won't be a fight with the beneficiaries. And I see that all the time between two sisters or brother, sister, etc. Parents put all this into place and might say, well, my daughter took care of me a lot more. My son lived in Atlanta, and so she's going to get 70% and he's going to get 30. And there's always a fight, even though it makes sense because she was there every day, etc. There's still often a fight because he's still a child and thinks that he deserves his fair share. And then lawsuits happen that he takes her to court saying I should have a more fair share, etc. And it actually drains the asset fighting it. So don't be surprised if you won't. Some of you might not know because you'll be passed away, but don't be surprised knowing that there's going to be a dispute. So a lot of times bringing the children into the planning early on is better than a big surprise at the end where that son thought he was fair share and finds out later. And go ahead.
Yes, you absolutely can. And we often build those into our estate plans for that reason.
Good answer
Yeah.
too. That's good.
Good question.
Yeah. Yeah.
So the notes I'm jotting down here, and this is a great discussion. Bring children into the planning early, so that to avoid expensive disputes. The other thing I wrote down is don't move to Atlanta. Stay home and take care of mom and dad. Okay.
We do find that we see that with families because we're oftentimes working more, unfortunately, more towards the end of life for a lot of our folks because they wait too long sometimes to go where they're going next. But we do see families that had no idea what was in the will, and they, just like you're saying, and we see the real life scenario of it, and even end of life wishes to discuss those with your kids or whoever your responsible party is in detail well in advance of when you're sick and need to talk about those things. Because it's good if there's questions to ask things. I know, just to get a little off track, when my dad was passing, we had great open discussions, but even a few days before he died, he had me sit. He was laying in the hospital bed at home, but he was on hospice, and he had me read through the will again with him sitting there and said, make sure if you have any questions, let's talk about it. And we went through, it's a hard time to talk about it then, but it was important because I had a question about something he said about the safety deposit box or whatever. It's much easier to ask those questions when they can tell you and you can answer than just get a document and then think, oh my gosh, I didn't know anything about this. What about this or that? So I agree. Communication is so important. So important.
And just another piece to that too, and we unfortunately run into this as well, is people will set up estate plans. And when we're dealing with estate plans, we're not just dealing with the end of life, what happens with my assets. We're also looking at things like powers of attorney and healthcare proxies that allow somebody to assist during somebody's lifetime. And the unfortunate thing that we will run into is that people will set up these documents, but never tell anybody who they've nominated, which is an issue. You have somebody, typically at that point, you have somebody who has an incapacity, who can't be acting on their own behalf, and their family is scrambling, trying to figure out who can, trying to figure out what they can do, what they can't do. So having, I have these discussions with my clients as well. Some want to tell them their children, their families, everything, and some want to keep things, closer to them, and that's okay too. What I always recommend is that let your personal representatives, your trustees, your attorneys, in fact, your healthcare agents know that you've nominated them, so that they know if there is an issue that they can step in, who they can turn to for questions as to what they can do. And there's no surprises. There's no scrambling at that point.
Okay.
Having alternate, absolutely. Yes.
Yeah.
Yes, it is.
I want to make one more comment on the probate piece too. For anyone that's single, adding that payable on death or transfer on death on like a checking account will avoid probate. If you don't, then that's a probatable asset. So we look at wills as it's just going to catch anything you didn't put someone's name on, because you should be able to put someone's name on it in some capacity, but sometimes people forget about their checking or their savings account and it's just their name. You can put something that says payable on death. Doesn't give the person any power, but then that's off the probate list, right? And your goal is to get as many things off the probate list. And she would be able to echo this. It's also public. Probate's a public moment that they publish those things when you go through probate. So a lot of times people want to avoid their business being publicly talked about, and anything you can avoid being in probate won't be published anywhere.
Good point.
Yes. Very good.
Question?
So that's a conversation that typically I would be having with my clients at the point of estate planning, taking a look at the assets that they have, taking a look at how they're set up. Typically, most commonly, I'm dealing with what's called a revocable trust, which is a very flexible estate planning document. So a revocable trust can hold real estate. It can hold bank accounts. It can hold non-qualified investments. It can hold personal property. So you can move all of those things into a trust. It's just a matter of following the steps to make sure they get in. So typically, when we're dealing with clients who have real estate, we're helping them to move the property into the trust to make sure that that is done properly. We're giving them a letter of instructions of what they need to do to move other assets in, and providing them with the documentation to make sure that they have the right things that a financial institution would be looking for to retitle those assets to transfer them into a trust.
So even like a bank account, you would put.
You can put bank account, even if you have a family member on the bank account with you, it can still go into the trust.
So this is a common conversation that I have with clients as well. What Casey was saying, if there is a named owner on that account, that goes right to that named owner when you pass away. And if your trust is contrary to that, typically it's going to be easier to move it into the trust to make sure your wishes are followed. So you're accomplishing really both objectives at that point. It's in the trust, so the trust is going to have language about who has authority if you lose capacity to step in and manage things. So we're not dealing with a question as to that. And we're also making sure that your wishes as to how those assets get distributed are followed. Versus if you have just one person's name on the account, you're relying on their moral obligation to follow your wishes versus their legal obligation to do so if it is in the trust.
Yeah,
Nursing home.
Yeah, that was one of the questions that we were
Yes.
going to get to about Medicaid eligibility,
Mhm.
and what that's we could have a whole seminar about that alone.
Yes.
About what is if that's if within your family and that's the plan and that's what you're looking to protect these assets against being eligible for Medicaid to care for your care at the end. Those plans can be put in place and put in motion,
They can.
but there's also some time frames.
There are time frames. There are certain drawbacks to doing that type of planning as well. That I would say, kind of going back to that misconceptions, that's one of the things that I have a lot of people come in that they don't quite understand, is that any of that asset protection type planning is going to require them giving up some degree of control over the assets and access to the assets. And I would say it's not uncommon that I'm meeting with clients where they were talking about the implications and they say, I don't really want to do that. So who do you have as trustee? Well, it's right in the name there. It needs to be somebody you trust. Sometimes that is a family member. Sometimes it's a child that is going to step into this role, fulfill their duties, and there's not going to be any issues. They need to have management skills. They need to be good at money management and also people management. As Casey was saying, a lot of times you don't anticipate there are going to be issues between family members when somebody passes away. Money does strange things to people, whether it's a lot of money or a little bit of money. And sometimes it's a little bit of money that's worse.
The next day.
Yes, absolutely. So having somebody that you trust to follow your wishes, to be able to handle that responsibility is huge. And building in layers too, alternates is very important. You may have one person that this is the person I know is going to be the best at the job. That's great. I want that person to be your primary. But what if they're not able to, or they just don't want to fulfill that responsibility? Who is your next in line?
So we were actually talking about a situation earlier that I have with someone. There's a lot of caution that I give from all the things that I see. Number one would be two siblings is kind of difficult sometimes because I've been deposed twice about siblings fighting where one trustee is willing to do everything and the other one isn't, even though they're both required to do that. I had one where there was 4 children. The oldest and the youngest were both co-trustees and they both had to sign off. The youngest wasn't ready to do any of that because of grief. And the oldest wanted to do this to help the other 2 siblings out. But another situation we talked about today was I have someone who is a co-trustee with a law firm. Problem is the law firm is pretty much not talking to him and he's trying to get help. So having a corporate trustee can be a little bit trickier sometimes too, because they're going to be really letter of the law, or there's a whole bunch of cases that they're working on. We do both when we see it, but at the same time, I often like to see a single trustee with someone as a backup if they can't do it. Because you also have to think, okay, my son or my sister or something, right, is the trustee. However, 20 years from now, when they might actually step in, what's their situation going to be, health-wise, etc.? It isn't today their situation. It could be you live another 25 years, and what is that situation going to look like? So oftentimes just looking forward to about who that trustee is going to be. But I've worked the best with single trustees that they can just do what they need to do, help the other siblings out, or do whatever has to be done, versus counting on someone else to also be in agreement, which is very difficult after the process starts.
So a trust is never going to fail because there's no trustee. A trust is always going to have language, if there's no specific person named, how to nominate the next person. And there's not to say that there wouldn't be complications in that. Say you have 20 beneficiaries and the trust says that a majority of the beneficiaries have to appoint the next successor. You've got some logistic concerns there, but it's not as if the trust goes away or there's issues there. The trust is still going to exist. But putting alternates in place makes sure that the administration goes smoother. It also ensures to make sure it's your wishes that are being followed versus the wishes of your beneficiaries.
So I think the point here is, and this brings me to my next question about, in case you bring up a good point of what happens 25 years from now. What we're finding is folks that we're working with, their children are older than we are as well, and our parents had us very young, and I feel like sometimes I'm the same generation as my folks. Some days in the morning I wake up and this is what that feels like. Okay, but to think about that. So, how often should folks review these plans and review these documents and all that goes with it? Things change.
Okay, so you said annually you review the beneficiaries.
Right. We do more of a life situation annual audit just to see if anything's changed or if they've had a falling out with someone, or there's a lot of things that can happen throughout the course of a year. My daughter married this guy and I don't like him and blah, blah, blah. Like, I see a lot of things like that. So we do more of that, like the annual financial plan review, just to make sure that all the moving parts are still the same. But we defer to the attorneys typically, 5 years-ish?
Yeah, so typically my recommendation is at least every 5 to 10 years reviewing estate planning documents. But certainly if there's a major life event, if somebody new is born, if somebody passes away, if somebody gets married, if somebody gets divorced, all of those big things are an opportunity to look at your estate plan as a whole and make sure it's still working to accomplish your objectives.
And a lot of times you don't have to rewrite it. You're just doing an amendment, like an insert in there to say, oh, now I have a grandchild and I want them to be provided for in some capacity. So you're not reworking the whole thing. You're just making an adjustment. So
now, where do people typically keep their plans? Do they They file it with the attorney's office. Do you keep it in a safe deposit box? Do you keep it in a shoebox in your closet? How does everybody know where it is, and who is it have to be an original copy? And can you speak a little bit on those things?
Certainly. So for probate purposes, we would need the original will. When we're doing estate planning at our office, we are typically holding on to those documents for the clients. We have a storage facility where they're all kept, they're all organized, we have a list, we know where they are. What we do for our clients is we put together a binder of copies of all these documents so that they have a binder of copies. It has our contact information right on the front, that they can keep that at their house so they have the documents available, but they know their originals are safe.
Okay.
So a will wouldn't actually get filed with the probate court typically until somebody has passed away, because a will can be changed while somebody's alive. So if we're filing it with the court and then it's changed, then we've got to now file the changes with the court. Versus if we have a will, it doesn't have to go through probate. We don't necessarily need to do anything with that will.
So a will or a trust document is different than a deed or
Yes.
a mortgage.
Yes.
That's
right.
That's recorded. Okay. All right.
How does the trustee and the executor of the will, how do those
Mhm.
how do they relate?
So an executor or a personal representative is a term we use now, is the person who's named to manage things in a probate estate. Whereas a trustee is doing all those same jobs, but they're operating under a trust. So it's a matter of what document they are operating under. They serve the same role. Their job is to manage and distribute. It's just a matter of where they're getting their authority from.
So if she was the executor of the will and I was the trustee, she's going to have her own list of things to do that don't necessarily apply to me because I'm following the trust instructions. So the will might say, I want my assets to be divided 50-50, but the trust might say, I want the assets to be divided 70-30. She's only going to work on those assets that apply to the will, and I'm going to follow the instructions of what the trust owns. So there's completely separate requirements with what they're going to have to do, which is why that superseding piece is important, because you might, if you change anything, you want to make sure that you change all the places. Okay. But we would operate independently, basically.
And if the will happened to say, if there are assets subject to probate, they go into my trust, then my job as personal representative is to handle the probate and then hand them over to Casey so he can do what he needs to do in the trust. There's no requirement that you have a trust. Certainly there are a lot of benefits to having a trust, but it's not a requirement. You can accomplish all of the same things that you can with a will that you can with a trust. It's just a matter of, are you looking to avoid probate? Are you looking to keep things private? For a lot of people, it comes down to cost as well. So there's no right or wrong answer there. It's not even necessarily a financial component as to what assets you have. I've had clients set up trusts that they have a couple $100s to their name. I've had people that have had thousands of dollars to their name that just have a basic will. It's more a matter of looking at what process is required and what those steps are and deciding what they want people to have to handle on their behalf.
And correct me if I'm wrong, the trust, you can create framework for things to happen, where the will is more of just an outright sort of scenario.
So you can actually create trusts within a will too. It's just a matter of, now we're dealing with a will through the probate court and administration of the trust through the probate court. There are lots of layers to estate planning. Sometimes it's very simple. Sometimes it can get a little bit more complex. And that's why, meeting with each client and discussing their particular needs helps us to put the best plan together. Because you're right, some people, a simple will, everything outright to my children, and it's done. Great. Some people have children that have, certain needs, or they have concerns about money management, and they want to kind of keep things as private, or they're disinheriting somebody and they don't want to have to notify them through the probate process. Then we're likely going to start talking about a trust to kind of keep that management more private.
Okay.
What does a typical time frame look like for probate? If someone needed to go to probate, are we talking 3 weeks? Are we talking 3 months, a year, 6 months? Does it vary? depending on what it is?
It can vary. So generally speaking, a probate can be filed at any point after somebody has passed away. Administration, the earliest point at which assets can be distributed under a probate estate is 1 year from the person's date of death. So, and that's not to say the personal representative can't be selling assets in the meantime or paying debts. It just means that you pass away on X date. 1 year later, that's the point at which your children or other beneficiaries could receive the assets under the estate. So everything estate planning is so client specific. So yes, you can certainly, put your children's name on your property, but you're right. That attorney is right. If something happens to them, that is an asset that's available. So it's an entire examination of all the factors that are at play. What are your wishes, but also what are we introducing as a possible risk factor by doing it that way?
Another thing would be if you put their name on it and you wanted to sell the land, they'd now have to sign off on it too.
Right.
Yeah. Because they're also an owner. So
Yeah.
Right.
That's right. So, these are all some really, really, really great questions
Yeah.
that are coming up as well. But to kind of come back up out of the weeds here for a half a second. I like living in the weeds. It's it's in the detail. That's what I like. But folks, and oftentimes we're working with a couple, a husband and a wife, and what we find in the when we're working with them, they work well together as a team. They're both going through life together and setting things up that the intention is that if I pass first, then my wife is the one that gets everything, or vice versa. But people age at different stages as well. And, potentially there could be someone that passes and the other one that's staying is either doesn't have the capacity to manage or those kind of things. Those, again, getting back to the question of how often should these things be reviewed?
5 to 10.
Yeah.
Still?
So I also wrote myself a note, get together with Brianna. I spent 5 years.
Brianna did our estate planning, but it's probably been 5.
It
At least
has
5.
been,
So
yes.
we need to rebook with you to go over everything because things change.
So for revocable trusts, now what a revocable trust means is that you are in full control. You can make changes. You are the beneficiary. You are managing those assets just the same as you are now, but you're taking steps to avoid probate. There's no look back period with that. Because the assets are still yours for all intents and purposes.
So, I'll just stop you there. So
Yeah, of course.
the assets are still yours, so they still count in your eligibility calculation of
Correct.
Medicaid.
That's correct as well. Yes.
Okay.
All right.
So for those, for revocable trusts, there's really not going to be any implications tax-wise for your lifetime. Any income generated by the trust is reported as you, just the way it is now. It's income to you. It goes on your tax return. With an irrevocable trust. Now, these are the type of trusts that we start to look to if people are looking and have concerns about long-term care. If they want to protect assets from being available, from being countable assets for long-term care, that is where a 5-year look-back period comes into play. And what that 5-year look-back period means is that if you are transferring assets for less than fair market value, whether it's to an irrevocable trust, whether it's an outright gift, whether it's by a life estate deed, which is another planning tool that we use. Those assets, if you need to apply for mass health assistance for long-term care, those assets, those transfers can disqualify you from care for a period of time based on the value of what you've transferred. Now, 5 years and a day later, they don't care. But if it's within that 5 years, it does matter.
So potentially they could be considered not eligible, depending on what the
Correct.
value of
Yes.
the transfers were.
Yes.
Okay.
And could you comment on the powers in an irrevocable? I think that's important.
Yes. So your power as a creator of an irrevocable trust is nothing. If it holds real estate, you get to live in the real estate. If it's generating income, you get the income. But typically any type of asset protection trust, you can't touch the principal of the trust. So say you transfer in $100,000, you can't touch that $100,000. If you transfer a house in that has equity of $500,000, you can't touch that $500,000. If you could, then guess what? You have an argument that's available to pay for long-term care too. So a lot of times it's a balance of factors. Do you need this asset? Do you have sufficient other assets available to support your lifestyle without this asset having access to it?
And someone else is in charge of that trust as a trustee
That's right.
too. So you could have a child, but then you have to ask them for things, etc. So because the whole purpose,
Right.
the whole
Need some
purpose
new
is to
sneakers.
put the money somewhere else.
Yes.
Right.
Yeah.
Like you don't
That's
have
right.
it anymore. You're stashing it in irrevocable trust, but that means it's literally not yours anymore. So that's why it'll count after the 5 years, because you have no control anymore. So when we've dealt with folks, that people want to do it, and I'm like, you can't just put all your money in there, because then what if you need to do this or that or that? You can't.
Right.
Like you're not able to access anything. So that's a big drawback a lot of times, that people just want to be able to qualify for mass health, etc. But that's poverty level to be able to qualify for that. You're giving away all your money, really. And a lot of times that's like what she said, people end up going, wait, maybe I don't want to do that anymore. Like that's changed. You can protect some of the assets through irrevocable,
Right.
but still have some others. But those are fair game, but at least you've put $500,000 aside that doesn't count anymore, right? Or a property or something like that.
I would say most commonly people are looking to protect their primary residence. You know, it's a family home. They have no intentions on needing to go in long-term care, and they're willing to take whatever steps that they need to stay at home. But if they do, they want to make sure that no liens are attaching to that property for their care.
So if that's the intent, that your message then would be to do that sooner than later,
Yes.
and not 5 minutes before you find out you're
Yeah, the time to plan for these things is not when you need long-term care.
right.
These are proactive measures that you would be looking to take.
Okay. Excellent. Very good.
It seems like what it really boils down to is making an appointment with financial planner and with an estate planning attorney to go over your specific situations, to really talk about all your things so you can get the right guidance from professionals as to what works best for your situation and what your true wishes are. Do you ever have trustees, appointed trustees or beneficiaries from a will come to these appointments with the client, or do you recommend that they do that without those people present?
So on my end, it really varies. Oftentimes, if it is somebody that has a child that's helping them out, we often get a call from the child to set up the appointment. And if, mom or dad is comfortable, the child's accompanying them. If it's somebody that says, you know what, I don't feel comfortable discussing this with my children, then that's fine too. At the end of the day, they're the client. So who they wish to share the information with, that's their decision. What do you find?
Many times we see the parent do it themselves in the beginning so that there isn't any argument at the moment. And then after, we do like a family meeting to say, okay, here's the situation, because it's already been done. So even if one child or beneficiary is upset, tough. It's already occurred.
Yeah.
They can take it up with it afterwards, right? But at least it's not going to be part of the discussion. They might not have a good Sunday dinner, but at the same time, it's not going to be a big issue that day, because they've already put the steps in process. We're just informing them, so that it's more of a bringing everyone kind of up to speed if the person's comfortable. Because sometimes they're not. Sometimes they're just like, no, they can deal with it when I go. I don't want to include anybody right now, which is fine. It's your prerogative.
Right. Right.
I would say that's a common thing I hear. What do I care? I'm going to be dead.
Right.
You know what? That's certainly one perspective that you can take. It also comes down to the language of the trust itself as to, certainly, yes, they may have the power to sell. Those are all part of your regular, I would say, trustee authorities. How they make distributions is going to depend on how the person set up the trust. So if the trust says, yes, the trustee has authority to distribute during the lifetime to these beneficiaries, then they can do that. But if somebody that's not named as a beneficiary, they're not going to be able to do that. So it's all very trust specific as to who or what they can do with the assets.
And your question about like timing of when to sell something, you mean just if they own rental property or something else? And if what we've run into is that's part of the family meeting oftentimes to see if the beneficiaries would want that asset in the first place. I have a gentleman in Worcester that owns multiple 3-deckers that rents to WPI students, and his kids don't want them. So he's like, okay, well, I sat with them, I talked, so he's going to start to liquidate them because he's like, there's no purpose in me having them inherit it, and then I'm saving them the trouble of having to deal with it, where I could just sell it, I'll take the tax hit, but now it's an asset that I can put into my trust versus them having to navigate, especially if there's multiple beneficiaries on the property and one wants to sell, one doesn't, and then there's a buyout, it gets really hairy. So a lot of times a family meeting will help determine that because there's a business too in this scenario. They want the business, but they don't want the properties, the rental properties. So they're like, yeah, sell those. Don't sell the business. We'll take that over. So I think it's very case sensitive, but talking to who would be inheriting is really important because they might not want what you think they want. Is the other part.
So in planning this process, do you go to the attorney first or do you go to you first?
I mean, often if it's something more of a financial decision, they usually talk to me. And then if we need to register something in a specific way, we talk to the attorney. We tend to work together.
Yes.
So it's part of really a team. So I tend to work with a CPA and an estate planning attorney as like a 3-headed monster in the scenario. I don't do taxes and I don't do estate planning. So I can't write wills. I can't write trusts. I can advise on how to fund them, like what the things are to do. I also can't do your taxes. So I have to defer to others. Same thing in her scenario. Like she doesn't want to talk about stocks and bonds, etc. She'd rather put your wishes in a document and then that comes to me. So you want to make sure if you do have an advisor, you have an estate planning attorney or CPA, that they know each other. They need to at least be aware of each other because you want to have them kind of on the same page. Okay. Because I tend to have a lot of people come to me for just any financial decision. I'm looking to do this or I'm looking to do that. How is it going to impact me down the road in my retirement? Those are the conversations I have. Or if they come to me and say, I'm looking to sell this thing, where should I put the money? Oftentimes I'll bring in the estate planning attorney and be like, should this go into this type of trust instead? And then they would set that up.
Well, because certainly in your world, when you're talking to folks about, providing income, for their lifetime and where's that income coming from? Is it from investments? Is it from a pension? What's the planning of that and how best to protect that as well? That's what comes into the conversation too, as well. So I wanted to touch a little bit about, the implications about gifting assets during somebody's lifetime and what's the advantages of that. Like you just mentioned, Casey, that the 3-deckers aren't very attractive to the heirs.
They're attractive to us as realtors, but not to the heirs. Yeah.
Well, so like that's been the family's income stream for 20 years because he retired, and that's been the income stream forever. However, the children have no interest in that. From a gifting standpoint, so it doesn't make sense for him to gift it to them because they don't want it. Right. But then at the same time, he doesn't want to lose the income stream from it. So he's in a rock and a hard place about losing the income stream and where he thought they would want it. The benefit to the gifting, though, is it gets it away from you personally. So when we talk about the irrevocable trust, losing control, etc., the gifting does put it behind the curtain where it's no longer an asset of yours for estate taxes, Medicaid eligibility, etc. I honestly don't work with anyone that's Medicaid eligible. It just is. Was it $2,000 right now?
$2,000 per person. If it's a married couple, the spouse staying in the community can have $157,000. So not a high level of assets that you can have if you're requiring the state to step in and pay for assistance. I mean, from an estate tax standpoint for an individual, if you are gifting something from Massachusetts, it's not part of your taxable estate. So say you're right on that threshold, $2 million is the threshold now. They recently increased it. If you're right on that threshold and you happen to gift something away, they're not going to look at that as something that's taxed as part of your estate. There are implications for the person who's receiving the gift, though, especially with real estate. So, and I'm not going to get into a huge discussion about tax basis because I am certainly not a tax expert. But if you are gifting something to somebody, they get your basis in the property. So say you bought it for, I'm just going to say $100. That's not realistic. But you bought it for $100. It's worth $500 now. At the point you sell it, you're paying taxes on that $400 increase. If something passes at your death, currently it gets a stepped up basis. So if that property has increased to $500 and you sell it for $500, there's no gain there. So there are advantages to getting that stepped up basis for the person who's receiving the gift.
And I'll piggyback that from a step up on basis piece with a situation I currently have. A woman's grandfather was gifting her stock since she was young. Shares of companies like Caterpillar, ExxonMobil, etc. And she came on board with us, and I looked at the statements, and her cost per share of something like Caterpillar was like $2 because she got it in the 70s. Now it's worth somewhere in the $350 a share range. So she's stuck with it too because she doesn't really want to sell it because of all the tax burden that she's going to have to take on her income tax. Where if that was a account he had for her in his name and she inherited at his death, it would be today's value, the cost. So if he passed away today, that share of Caterpillar that she'd inherit would be at today's price. So really, I think when you gift, that's another piece to really be aware of. If you're trying to, and this is where we get a little bit more in the weeds, but if you do have things that you're trying to gift away, we're kind of dovetailing into the charity piece of it. If you write checks to the church, if you write checks to the ASPCA, Cancer Society, etc., you can gift a lot of these appreciated things to them instead of writing a check. Okay, so I don't want to get in the weeds with taxes, but also in your IRAs that you have to take out every year, you can do part of that required distribution to a charity and not have that taxable to you either. So if you have to take out $5,000 from your IRA every year and you give your church $1,000, but you write a check out of your bank account, you could actually take that $1,000 from your IRA and it isn't on your income that year. Okay, so there's some ways too in the gifting side that you could alleviate taxes too. That's in a good way, but just be, I guess, careful of what you're gifting and who you're gifting to.
And the tax implications on both sides of that equation. So best to consult with a CPA.
Yes.
In those kind of situations. So
Those are more important documents than having a will or a trust. Because
a power of attorney and
yes, and a healthcare proxy.
Healthcare proxy.
Yes.
Okay.
Because a power of attorney allows you to appoint somebody to assist you with financial and legal matters while you're alive. And a healthcare proxy allows somebody to step in and tell medical professionals what your wishes are if you're not in a position to express those. So if you don't have those in place and you lose capacity and somebody needs to be able to do things for you, we're typically petitioning for guardianship or conservatorship through the probate court. So now we're back in the court dealing with that process. It can be a lengthy process. It's an expensive process. It ends with us standing in front of a judge and asking them to appoint a guardian and a conservator. Don't recommend it. So very much easier to have that power of attorney, to have that healthcare proxy in place. The benefit of that too is that you know who you're appointing. You can give them a heads up. Hey, I need you to step in and handle these things for me if I'm not able to. Or these are my medical wishes. If there's ever a time that I can't express them, I want you to tell them what I want.
I would say, depending on the financial institution, a lot of them have those tools where you don't necessarily have to go to the attorney. So in our firm at Merrill, on IRAs, we have our own document that's a power of attorney. So if you didn't have one, you could come into my office and fill out a power of attorney for that specific account, so that if you had a stroke and you still need to take money out, etc., that person can do it. It doesn't, that's kind of the tricky part sometimes of power of attorney, is it's for everything, right? Like if you go to her and there's a power of attorney, that's now, they can pretty much act on your behalf, anything you do.
So it wouldn't be just for that account that you filled out in that situation particularly.
They could show it really anywhere.
Correct.
As now they're your stunt double.
Okay.
Really?
Great way
Okay.
of putting it. Yeah. I'm going to use that. Thank you.
Right. All right. So, but some firms like mine will have just specific account power of attorneys too, where you can get that done today with me, for instance, on a IRA that you've had forever from your retirement, etc. And you can check different boxes. It gives them permission to do withdrawals. It gives them permission to make my required amount, to do other things, not to do trading. There's things you can eliminate too. So if you haven't done anything, a lot of times financial institutions might have that ability on a specific piece. We tend to not, we really are critical of external power of attorneys, because the language has to be perfect in our view at the legal department, because a lot of times it might just be too vague and it doesn't really give that much permission for the things that we need to have happen on the account. But there's blanket power of attorney versus account specific. So just kind of a last minute thing if you did never do anything. A lot of times you can do that.
Okay, great. As always, I wanted to ask both of you, is there anything else that you would like to share that either you prepared that we didn't cover today, or anything else that's important to highlight?
Let's see.
I think we hit on most of my main points. I meet with a lot of clients, so these are all common things that are coming up in my conversations with them.
I just have a quick question.
Yes.
So we're talking about revocable, irrevocable trusts, other types of trusts that
So a trust is either going to be irrevocable or revocable. Those are kind of your basics. There are nuances with all types of trusts, things that you can introduce. There are trusts that are specifically just to shield who the true owners of property are. So those are nominee trusts, but they're not a true trust. So there are different types of trusts. Generally speaking, at a high level, we're dealing with revocable versus irrevocable. So it's now $19,000 per person per year, but that is for federal estate tax purposes. $19,000. So that adjusts every year, but that's a federal estate tax matter. It's not, you're still making a gift. So they would still look at that and say, look, you made a gift here. So it's different purposes.
So that's still part of the look back.
Yes, it's still part of the look back.
Under,
No.
as income for
taxes.
under taxes? That's the
No.
question? No.
No. So they would still say that's a disqualifying transfer.
Which is why everybody should do this now.
Yeah.
Plan.
Yeah. I know it's the best time when you're feeling good, when things are going
Yes.
well, to do it, as opposed to waiting, because we know tomorrow's never promised and these things happen. And then all of a sudden you say, I should have done the appointment. I should have made the renovation on my house. I should have done so many things. So
I should have went to Hawaii.
should have went to Hawaii.
Yeah.
But yeah, so definitely connect with both Brianna and Casey if you're interested more in their services, and want to find out more about setting up an appointment. I think we all can benefit, including us. We're going to get on your
Get on
calendars.
the
All right.
calendar.
Yeah.
So let's give Casey and
Yeah.
Brianna a big round of
Super.
applause.
Thank you.
Good job, Brian. Good job.
So we'll be here for a little bit longer to answer some more questions as well. Just to let you know our upcoming events next month, we're right back here in Leominster, June 11th. Assisted living options. We'll have a panel of assisted living communities in the area, and hope you join us for that. That was a lot of fun last year. And then July 9th, something new, mindfulness and meditation for seniors. That's going to be gonna be really zen. Yes. It's
Very calming.
very calming. And we'll have mini splits. Be nice and cool.
Be cool. Yes.
We hope to see you then. We'll be around answering questions as well. So thanks for coming.
Thank you.
Everybody. Appreciate it.